Welcome back to another episode of the Corporate Cowboys podcast. Man, we'll get right into it. Little proof of life. It's Saturday, April 29, 2023. And if you're not familiar with the format of this podcast, treat this as a free 30-minute consultation. Like you walked by our office and you saw the door was cracked open and you're like, you know what? Alex doesn't usually leave his door open. Yeah, I try to put these episodes out as frequently as possible, but time is money. So if I'm being charitable, if I'm being generous with it, it behooves you to get your foot in the door, because ultimately that's how you move up in corporate. You taking the initiative and acting on it. Well, today's question, it's as if somebody walked in, right? They don't have anybody else really to go to. Their circle of friends or associates may not be so corporate minded, so they want to get some perspective from a corporate cowboy. What would a corporate cowboy do in this situation? The question is coming from r/career advice, and they're writing, I resigned. Damn. Okay. That could be a positive step and a negative step, right? But it is a formal step. Maybe you got something lined up on the side. Maybe you don't. Maybe you were leaving because the environment was unprofessional or unbecoming of a consummate professional in the making. Any number of reasons, right? It could have became bad blood. Could have been forced. Inevitably, this happens. They write, I resigned. And the employer is asking for proof of next employment. Okay. The employer. I was going to say, well, isn't that your former employer? But you resigned. So you haven't terminated employment yet. They're technically still your employer, technically, because resignation doesn't mean termination, right? It's a notice of resignation. And depending on the amount of time you give for your notice, at the end of that notice period is when you are officially terminated, or when you officially terminate whatever contractual agreement you had, whether it was employment, salary, or just an independent contractor, right? You give notice, and at the end of that notice is when ties are cut. So in that span of time between giving notice of resignation, right, formally submitting your 2 weeks or whatever professional courtesy it is you're giving them, it could be a month, it could be 2 days, it could be the same day. Hey, I'm leaving, I'm bouncing. Alex, but wait, nah, fuck this shit, I'm out. Depending on what the situation calls for, that period between you formally giving them notice and that notice finally expiring so that the employment relationship terminates, they're technically still your employer. You're technically still their employee, right? So in that span of time, if they're asking for proof of next employment, you don't have to give it to them. What the fuck? They can't force you to tell them where you're going next. You could be going to, you could, in theory, be going to the fucking competition, right? And so long as your employment agreement doesn't have some kind of anti-competitive or competition provision, some non-compete, right? You're good to go. And even then, many non-competes are not drafted correctly or they're not legally enforceable. So if they're asking you, it may be for good reason, but you don't necessarily have to tell them. If that were the case, they would have drafted it in the agreement there, where if you plan on resigning, you must inform them of your next employer so that they can do some kind of conflicts check and find that you're not leaving for the competitor. But even then, if you're going to another professional outfit, that outfit more than likely already has its own conflict checks in place. So when you come on board, they're making sure that they're not stepping on anybody's toes because they don't want to hire on a liability or a potential liability. If they know you're coming from the competition, sure, they might poach you and recruit you. I mean, there's a number of tactics, really. They might draw you away. They might draw you away from the company knowing you cannot compete. And so effectively taking out a very capable agent from the corporate war. Business is war, baby. You're born into it. Get over it, right? So it serves the same as eliminating an enemy combatant, eliminating one from the opposition without having to commit to bringing them on or anything, right? Now, there's also legal causes of action in that too. It could be tortuous interference with contractual relations, but I mean we're digging deep. That's more higher level thinking, right? More higher level thinking and strategy that rarely does it manifest and become reality. Rarely. If you yourself find yourself in that position, or you know someone who is or has been within the past, I'm gonna say year or 2 years in most jurisdictions, and that's an easy safe harbor. Have them hit us up. DM us. That's what we're here for. We'll try and consult you, give you some perspective, walk you through it, guide you per se. If you want to retain us, you need legal representation. And if it ain't us, we can refer you. We can refer you. That's what we're in the business for. We don't just handle contractual negotiations. We handle disputes too. And getting them resolved. Amicably, I might add. Right? We wanna terminate relationships on good terms. Always. I'm not a fan of bad blood. That'll smack my mouth a little bit. I'm not a fan of bad blood. It just smacks of just smacks of iniquity. It just smacks of dirt. Okay. my mind took off running and I just kept from saying what it was thinking. So let me go ahead and read some of this prompt here. And along the way, I'll interject with some commentary and added perspective. The template, for the most part, I mean, it's recommended. I insist that you have the client in front of you. But because we only have these words to go on, we're banking or we're gambling on the fact that they're writing down and being vulnerable, being open with these vulnerabilities, this situation that they find themselves in. It's not hard. It's not hard to be vulnerable, but it's very difficult to be open and to be concise when you're asked questions or when you're asked for information. Because doing so, I mean, the client always wants to be right. And sometimes they're not. Unfortunately, regrettably, they are not. But it happens. It happens. So if we have the hypothetical client, if we had the client in front of us, we might better inform an opinion for them, some type of advice, legal or otherwise, of how to approach the situation they find themselves in. Now, a legal disclaimer, I got to give it to you now, is that anything that's said or repeated on this podcast, you should not construe to be legal advice for you. We do not condone or promote any wrongful activity or any wrongdoing. We're not responsible for you having heard this podcast and getting any bright ideas. All right, so they write here. They say, hi. I put down my papers at my current job. Bam, just throw them on the desk. I fucking put my papers down. I put my foot down on my papers. And they are apparently not happy about it. It means one of two things. It means they have to change their modus operandi of how they were when you were there. Now they have to change up because of you. And if we know corporate like we know we do, it's any change equates to more work. And if it's one thing motherfucking fat cats dislike, it's more work. Even if the change is good, even if it's a net positive, they hate undergoing it, which is why you see capitalism having strayed so far from its pure beginnings. The strain of capitalism that exists now, I mean, it's infused, it's entangled and intertwined with corporate interests. And corporate literally meaning bodies of individuals. It's just inanimate bodies. It's just groups. It's group interests. That's where business is war. And you're born into this corporate war. And there's groups within groups. What you think they're even, it's become further fractalized. You think corporate interests are any purer than capitalist interests? Nope. There's a ton of infighting in corporate also. That's what shareholder actions are. That's how leverage buyouts and takeovers come into play. These corporate terms that have been synonymized with terms of warfare. It's something we're born into. It's something we're born into, and very few wake up to the reality. They're stuck in the matrix. Everybody technically is plugged into the matrix. Awoke or not. Awake or not. It's understanding. It's understanding your relation to the system, right? And as a corporate cowboy, our objective is to empower you, to have you level up from just being the lowly individual, the quote unquote, the little guy, and move like a corporate cowboy. Move up to their level. Learn to shoot from the hip. You can negotiate with them directly. If they don't want to take the hits face on, head on, it's because they're going to deflect. They're going to say, oh, we're not a real human. We're a legal person. Nameless, faceless. Nope, they got names. They got faces. I've seen it. I've done it. And it's easy. It's easy to be vulnerable. It's difficult to be open. So, as a faceless, nameless, I mean, I guess my name is Alex, right? But you can hear my voice. So I'm letting you know that the hard part, really the hard part, is taking your good ideas and making them reality. Step one is understanding what you signed up for. And that's been one of the many overarching themes of this podcast, is to read what you sign up for. Sure, there's going to be, fucking applications and software licenses that you're just going to click through like, yeah, I agree to the terms and conditions. You have to understand the worst case scenario is that they own all the moves that you make, right? And they could claim legally, but in reality, outside of the matrix, they can't do a whole lot, right? I mean, we're talking more on the street. So any good ideas that you have in your mind are on the street. You don't want to just whip them out and move through corporate with them unless you absolutely have to. and are sure that it's open and shut. Going off on a tangent, but I'm getting somewhere. Let's continue a bit. They write, so they put their papers down at their current job, and they are apparently not happy about it. I did not want to divulge too much information about where I'm going since it is my personal decision. Now they are asking for proof of where I am going in the form of a joining letter. Sounds like fucking bullshit. I think this is highly unprofessional on their part. How do you think I should handle the situation? Say no. Say no. Now, if it's, be mindful though that corporate runs on paper still. I mean, okay, technically paper, but corporate runs on receipts and records, right? Granted, a lot of receipts and records can also be erased, which I have seen. So any email exchanges, any texts, any phone calls that you are able to record, I'm not going to say legal or otherwise, but anything that you are able to record, you want to copy and keep in a place if you believe that those conversations might lead to a dispute further down the road, or if those are receipts that you'll need to cover your ass, to cover your entry, to cover your exit. So, if they're asking for proof now, and it is in writing, don't for a second let it slip that you caught them lacking. Oh, they're being unprofessional. No, if they ask for it in writing, it's because they want you to have a record of it. And I go back to what I said earlier. If you had read your employment agreement and you are obligated to disclose that because of some non-compete provision in your employment agreement, you might as well give it up to them, regardless of if it's your personal choice or not. You fucked up earlier on by signing on to this employment agreement, and maybe you read it and didn't think anything of it. Maybe you read it, or maybe you did not read it and never considered it. But a non-compete is a non-compete. That's if you're in a jurisdiction that enforces non-competes. A lot of the US doesn't, because it's kind of an infringement on the right to work, right? And thank goodness we got the right to work, right? I mean, for a little bit it was flipped upside down on its head there. It used to be fire at will. But motherfuckers smarten up. Motherfuckers as in corporate Cowboys smarten up and learn we can fire back. And so now they call it right to work because, fire sounds a little too militaristic. Sounds a little too militant. But that's the whole point of watering down language, making it all politically correct so they can fuck you smoothly and you'll thank them for it. That's some corporate cowboy shit. You want to go back to season 1, I think season 1, episode 1. It might even be the skeleton key when it comes to hustling. I think in season 1, those are pretty long episodes. They're like an hour and a half. This is back when, time is still money, right? But I was just laying down the foundation of the podcast, and it was a lot more therapeutic, a lot more cathartic and drawn out. But in today's day and age, I bill for time, right? So 30 minutes for me that you're getting is an immeasurable in value. It costs me 30 minutes of my time, but it's worth, if I had to quantify it legally, it's going to be like what I make in a year divided by 52 weeks divided by a 40-hour work week, blah, 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 blah. however many number of hours it is I work and what I charge for them. But I'm not the topic of conversation, right? You resigning and having to disclose where you're going is the topic of conversation. So if I was in that position, which, let's face it, I just might, they catch me lacking. They catch me without my reading glasses. I'm being facetious. I'm bullshitting. But if I, for whatever reason, did not read the employment agreement and there's a non-compete clause in there, I better know damn well that I'm in a state or I'm in a country where non-compete clauses are just thrown out. They're just not enforceable. Whether or not you go to the competition. Otherwise, you're shit out of luck. You will have to disclose it. If that means you have to go consult a lawyer, then you got to go consult a lawyer. It is what it is, right? You need a lawyer, hit us up. We might be able to refer you depending on what states you're in. But for the most part, I mean, you can find a lot of this information using your favorite search engine also. Now, if you plan to litigate it or argue against it or break that agreement to not compete with them, you better come armed to the teeth. And then we're back on that business is war shit. Yeah, at that point, you better pull out all the stops. You need a lawyer. You might need something for yourself. And what I mean by that is, I don't know, something equivalent to knowledge. Knowledge is power. Arm yourself with knowledge, if you recall. I've said before, arm yourself with knowledge or something similar that you can use to break out of this agreement or have them agree to waive it for you. If you're going to the competition, maybe it's for good reason and they can waive it. They'll be like, yes, okay, fine. You can go work for the competition. You could move in a way that makes them not waiving it miserable for them. You can make it, you can still make it a win-lose, or I don't want to be petty and go lose-lose, but there is always a way. You could have the company that's taking you on, that's hiring you on, agree to indemnify or to protect you in the event that you get sued, right? I mean, you are the professional, you are the talent after all. And if they recruited you and they hired you and your former employer says, Alex, you piece of motherfucking shit, now we're suing you because you went to their top competition. You had something to offer that your former employer didn't want to pay you for, and now you're trying to get paid? Fuck you. We could have used that. Well, guess what? Alex would have stayed if you did pay. Now look at me, sitting pretty. I'm sitting up, pushing P, he said. Still, you want that agreement in writing with your new employer. If they agree to indemnify anyone who comes after you, to sue you, and protect you. If anything, you could even preempt that. And they'll protect you if you should happen to get sued. Right? So that way you won't even have to go to court. You're using company money on company lawyers. Nothing comes out of your pocket. But again, that's more higher level thinking and strategy where you have to know how to negotiate, what to negotiate for, what it is you are reading yourself into, and at the end of the day, you will be signing the dotted line for. So they say they want it in the form of a joining letter. And to me, it sounds legit. I'm erring on the side of legitness. That's legitness. I'm erring on the side of it being legitimate. Because if for no other reason, that's why they're asking you for that offer letter, for that joining letter, because you're joining another firm and they want to be sure that the firm you're joining is not in conflict with any of their corporate interests. If you're joining the competition, it better be for good reason. It's more money and more cover, less liability. Those are probably the three reasons that you would be leaving at this point. More money, more cover, as in more professional cover, opportunities, resources, and less liability. You want more freedom, more liberty. I mean, we're talking within the corporate system. The US as a whole, the government is a corporate entity, right? I don't want to dive into that needle stack, but it's a corporation also in and of itself. And you move up those rungs, it comes with different degrees of power and control and authority. But at the end of the day, everyone is entry level forever. The shit doesn't change. It's the same soup, different flavor. It just depends who's stirring the pot. No one knows. No one knows what's being cooked except for the one stirring the pot. An OG once told me. So be mindful. Be mindful if you're going to be the one going into the kitchen, putting hands in the kitchen. I mean, you got to take the heat. You got to take the heat and also learn or know going in how to work the knives. Let's read one or two of these comments real quick. The first one says, simply decline. It sounds too simple. I don't know if it's too easy. It might not be the right move. It sounds too easy. It's like someone saying, "Oh, you got sued. Oh, they sent you a summons. They sent you a little proof of service, a summons letter. Fucking ignore it. That's easy. Don't even go." That's how you fuck up and catch default judgments. If you don't show up to defend a potential case that might have merits, that might be legitimate, if you don't at least go to get it dismissed, you might be the one fucking up. Now, that opens a can of worms as to what cases you can ignore, because there are some instances where you may be named, but it gets thrown out on its own. That being said, they continue. They write, unless you have an employment contract calling for such disclosure, you are under no obligation to provide that or any other information. Very aptly put. Very aptly put. Simply ignore it, right? Simply decline it unless, they do condition it with that unless it's what you signed on for, right? So I was right from the get. I had a good inclination, a good feeling about reading, right, before signing, so that you know and understand your obligations in the event that you terminate the employment, right? At resigning, and the reason being that you're leaving to another company, they're going to want to know. I mean, be happy that the disclosure is up front. That's if the non-compete provision includes that disclosure, and how you should give it to them in writing, right? They want it in the form of a joining letter. They know you're going somewhere. You told them you're going somewhere. So that's what they want to know. If you need help planning your next corporate move, right? Say you're leaving a firm. Say you've exhausted your opportunities for growth, your opportunities for professional development at the firm you're at now, and you want to leave. You're a talented individual. You know you deserve more. You understand your worth on the market, and you stand to gain more. Before signing the new offer, understand what it is you're agreeing to and evaluate whether or not you can negotiate to improve your compensation, to improve the coverage you're getting in the form of opportunities and resources, and decrease your liability. You are the professional. You are the talent. If there is any blood, if there are names and faces in corporate, it's yours. So know your worth. Corporate can stand to protect you because you're working for them. And when you understand that you enter this agreement, you are entering the employment agreement for money, is when you understand your power to negotiate and work with corporate, not just for it. You can find us on Instagram. That's at Corporate Cowboys with a Z. The Patreon is up and running. That's the Corporate Cowboys podcast. There are a couple of donation links available too if you want to spot us a couple of dollars. Keep this podcast free. It goes towards business expenses and legal fees, office supplies, that sort of thing. Take care of yourself. If you need help, know who to go to for it. Till next time.